Hello everybody, hello. Little extra bonus live today. I haven't had a chance to get through the Blessingame case, so I thought I had a little bit of time this afternoon, so I figured we could go through it a little bit since I had just a little bit of time. So let me get everything set here. So hopefully I'm in frame okay. 1 minute. I have turned off the comments so I can just get through the document itself for everybody. Sorry it's so wiggly there. I'm still working with a new tripod and I'm getting used to it. So let me make sure it stays in place. Okay, here we go. That seems to be all right at this point. That is the one thing about having the comments off, is I can't quite tell if I'm in frame or not. So everybody, I did start reading through the Blessingame appeal last Sunday. Didn't make it all the way through. We did run out of time. So I thought I would take some time today and go through it again, just reading through this document. This is the Court of Appeals decision. This came out on December 1st of this year. This was a civil lawsuit that had been filed by DC police officers as well as Congress people regarding Mr. Trump's actions on the 6th. They had put together multiple petitions. They've all been consolidated. And in these petitions, they're suing for harm. Mr. Trump filed a motion to dismiss, and the lower court denied that motion to dismiss. So he appealed it to the U.S. Court of Appeals, and now the Court of Appeals has come through with this opinion also denying that motion to dismiss, and they set out some very interesting reasons why. Now, the Colorado Supreme Court is supposed to be hearing oral arguments today on the 14th Amendment, Section 3. So I thought it would be appropriate for us to go ahead and go through the rest of this Court of Appeals opinion. I will start at the beginning for anyone that was not with me here on Sunday, so I can just start from the beginning, and I will just be reading through it. I won't be doing any annotations. I already did annotate, so we can just get through it. This was argued December 7th of 2022. It was decided December 1st of 2022. It is Blessingame and Henby versus Trump. Again, this is an appellate decision for the District of Columbia Circuit. So here we go, everybody. This opinion was given by the Chief Judge, set out here. Hopefully I'm in frame well enough. Fingers crossed, everybody. Since the Supreme Court's decision in Nixon versus Fitzgerald, presidents have carried out their official responsibilities free from any exposure to civil damages liability. Nixon established a president's absolute immunity from civil damages claims predicated on his official acts. The object of a president's official act immunity is to assure that he can fearlessly and impartially discharge the singularly weighty duties of the office. The president, though, does not spend every minute of every day exercising official responsibilities, and when he acts outside the functions of his office, he does not continue to enjoy the immunity from damages liability just because he happens to be the president. Rather, as the Supreme Court made clear in Clinton v. Jones, a president's official act immunity by nature does not extend to his unofficial actions. When he acts in an unofficial private capacity, he is subject to civil suits like any private citizen. This appeal calls for us to apply those key decisional precedents on presidential immunity to a decidedly unprecedented event involving the presidency, the riot at the Capitol on January 6th of 2021. Just as Congress convened to tabulate the Electoral College vote and declare the person elected president, the plaintiffs in the case before us are Capitol police officers and members of Congress who were at the Capitol that day. They seek civil damages for harms they allege they suffered arising from the riot. Although they sue various persons, the sole defendant named in all the cases consolidated before us is former President Donald J. Trump. The plaintiffs contend that during President Trump's final months in office, he conspired with political allies and supporters to obtain a second term despite his defeat in the election. He allegedly advanced that cause before January 6th by repeatedly making false statements that the election might be and then had been stolen, filing meritless lawsuits challenging the results and pressuring state and local officials to reverse the outcomes in their jurisdictions. Those efforts allegedly culminated in a 75-minute speech. President Trump delivered at the rally on January 6th, according to the plaintiffs. President Trump's actions, including ultimately his speech on January 6th, sparked the ensuing riot at the Capitol. President Trump moved in the district court to dismiss the claims against him, including on grounds of a president's official act immunity from damages liability. The district court largely rejected his claim of immunity, and President Trump now appeals. The sole issue before us is whether President Trump has demonstrated an entitlement to official act immunity for his actions leading up to and on January 6th, as alleged in the complaints. We answer no, at least at this stage of the proceedings. When a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of the office. So, when a sitting president running for a second term attends a private fundraiser for his re-election efforts, hires or fires his campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He is acting as an office seeker, not office holder, no less than are the people running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. President Trump himself recognized that he engaged in his campaign to win re-election, including his post-election efforts to alter the declared results in his favor, in his personal capacity as a presidential candidate, not in his official capacity as sitting president. That is evident in his effort to intervene in the Supreme Court's consideration of post-election lawsuit challenging the administration of the election in various battleground states. He expressly filed his motion in the Supreme Court in his personal capacity as a candidate for re-election to the office of president, rather than in his official capacity as sitting president. And he grounded his claimed right to intervene in the case in his unique and substantial personal interest as a candidate for re-election to the office of president, rather than in any official interest in exercising the office's duties. In arguing that he is entitled to official act immunity in the cases before us, Trump does not dispute that he engaged in his alleged actions up to and on January 6th in his capacity as a candidate, but he thinks that does not matter. Rather, in his view, a president's speech on matters of public concern is invariably an official function, and he has engaged in that function when he spoke at the January 6th rally and in the lead-up to that day. We cannot accept that rationale. While presidents are often exercising official responsibilities when they speak on matters of public concern, that is not always the case. When a sitting president running for re-election speaks in a campaign ad or in accepting his political party's nomination at the party convention, he typically speaks on matters of public concern. Yet he does so in an unofficial private capacity as an office seeker, not an official capacity as an office holder, and actions taken in an unofficial capacity cannot qualify for an official act immunity. While we thus reject Trump's arguments for official act immunity at this stage, the result is necessarily tied to the need to assume the truth of the plaintiff's factual allegations at this point in the proceeding. Trump has not had a chance to counter those allegations with facts of his own. When these cases move forward in the district court, he must be afforded the opportunity to develop his own facts on the immunity question if he desires to show that he took the actions alleged in the complaints in his official capacity as president rather than in his unofficial capacity as a candidate. At the appropriate time, he can move for summary judgment on his claim of official act immunity. Because our decision is not necessarily even the final word on the issue of presidential immunity, we of course express no view on the ultimate merits of the claims against Trump, nor do we have any occasion to address his other defenses, including his claim that his alleged actions fall within the protections of the First Amendment, because they did not amount to incitement of imminent lawless action. He did not seek appellate review at this time of the district court's denial of his First Amendment's defense, but he could bring that issue before us in the future. We also do not opine on whether executive or other privileges might shield certain evidence from discovery or use as the litigation proceeds, nor does our discussion on a president's official act immunity from damages liability in a civil suit treat with whether or when a president might be immune from criminal prosecution. Instead, we hold only that, taking the allegations in the plaintiff's complaints as true as we must at this point in the proceedings, Trump has not demonstrated an entitlement to dismissal of the claims against him based on president's official act immunity. In the proceedings ahead in the district court, Trump will have the opportunity to show that his alleged actions in the run-up to and on January 6th were taken in his official capacity as president rather than in his unofficial capacity as presidential candidate. Section 1, Sub A. Because this appeal comes to us on the denial in relevant part of a motion to dismiss, we assume the truth of the factual allegations in the complaints. We also draw from the complaints in all three cases consolidated before us, and because the sole question we consider is whether Trump has shown that he should have been granted a dismissal of the claims against him on the grounds of presidential immunity, we focus on the allegations about his actions rather than those of the other defendants, and in particular on the allegations pertaining to his entitlement to official act immunity. Trump served in office from January 20th of 2017 until January 20th of 2021. In 2020, he ran for re-election on the Republican ticket alongside then Vice President Michael R. Pence. They faced the Democratic nominee, for then former Vice President Joseph R. Biden Jr. and his running mate, then Senator Kamala Harris. According to the complaints, Trump began sowing doubt about the integrity of the 2020 presidential election well before the election, often via the platform they called Twitter, and continued to do so through Election Day. He posted the numerous tweets recounting in the complaints and related herein via his personal account. And here's first tweet. I will not be speaking the actual words of the tweet because I do not want to have any problems with the algorithm because I could get dinged for spreading false information. So this is a direct quotes here. If you are interested, you can pull the case yourself. That August, he stated that the only way we're going to lose, and again, there's the rest of his quote here. And in October, he posted a tweet accusing Democrats of trying to do something with the election. The plaintiffs allege that Trump communicated the same message in the first presidential debate in late September, where he stated, "This is going to be something like you've never seen. It's rigged. The Democrats are cheating and found things in trash and that had his name on them." The plaintiffs also contend that in the same debate, President Trump declined to conclusively reject the idea that the results might warrant a potentially violent response. When invited by a moderator to urge his supporters to stay calm following the voting day and not to engage in any civil unrest, he responded, "If it's fair, I'm 100% on board. But if I see tens of thousands of ballots being manipulated, I can't go along with that." Again, I am being careful of my language, everyone, so I do need to watch certain words for the algorithm. On day November 3rd, early returns showed Trump leading in key states, but as states began processing more of these, his lead started to dwindle. Soon after midnight on November 4th, as returns continued to come in, Trump tweeted this phrase here. The following day, he reiterated his claims of a stolen election, tweeting multiple other things. He echoed the claim late that night, tweeting various other false phrases that I do not want to perpetuate here on TikTok. On November 7th, all major U.S. news outlets projected that then former Vice President Biden and then Senator Harris would win the election. Trump did not concede. Rather, over the ensuing weeks, he continued to assert that the election had been stolen. For example, he tweeted that Democrats had done something bad. Trump also attempted to alter their declared results by various means. According to the plaintiffs, those efforts sought to further the sense among his supporters that something had been stolen. For instance, Trump and his allies filed 62 lawsuits in state and federal courts around the country that sought on various theories to overturn the results in key states. Virtually all of the lawsuits were rejected outright. In addition, Trump tried to persuade state and local officials in Michigan, Pennsylvania, and Georgia to use their offices to change the declared results in their jurisdiction. When members of the Electoral College met in their respective states on December 14th, they collectively cast 306 of these for then President-elect Biden and 232 of these for Trump. Accordingly to the complaints, Trump then began focusing his efforts on Congress, which was set to meet on January 6 to officially tabulate these and declare the next president pursuant to the Electoral Count Act. On December 19th, Trump posted a tweet referencing a report that, again, I cannot repeat on this social media app. Trump further stated that it was statistically impossible for him to have done certain things. He added that there would have been multiple other things that I cannot say on this app. So I apologize, I am skipping down here. Meanwhile, plans for the January 6th event, which became known as the Save America rally, took shape. According to the complaints, the rally's organizers, including the group Women for America First, at least one Trump campaign staff member and a Trump campaign fundraiser, secured a permit to hold the event at the Ellipse, a large lawn just south of the White House. The permit listed the Trump's campaign director of finance operations as the rally's VIP lead and named Event Strategies Incorporated, which received payments from Trump's campaign roughly 3 weeks before January 6th as the event's production vendor. More generally, the complaints alleged that the Save America rally was privately funded and that the Trump campaign or persons associated with it were involved in organizing and funding it, although there is some variation among the complaints on the particulars. According to one complaint, the rally was a private event organized by Trump's former campaign staff and arranged and funded by a small group, including a top campaign fundraiser and donor. Another complaint alleges that the campaign itself funded the rally, and the third complaint contends that a top campaign fundraiser oversaw the logistics, budgeting, funding, and messaging for the rally. One of the complaints also alleges that Trump participated in planning the rally, including by weighing in on speaker lineup and music selection. The complaints also describe Trump's promotion of the rally via Twitter in the immediate lead up to the event. He reiterated his claims of this on January 5th, saying this sentence here, which I again am not going to say on this app. The night before the rally, for instance, Trump tweeted, "Many states want to decertify the mistake they made." Again, I cannot repeat this language here. The Save America rally began at 7 a.m. on January 6th at the Ellipse. For several hours, a slew of prominent supporters of him gave speeches decrying this and demanding corrective action. He was the final speaker. He took the stage at around noon and spoke for roughly 75 minutes. Although the complaints do not contain the full text of his speech, they quote liberally from it, and the district court considered it in its entirety, analyzing it beyond the words quoted in the complaints. The parties have thus treated the full speech as incorporated into the complaints, and we will do the same. And they're citing the full transcript here. And I apologize, there are some words and some phrases that are not good to use on this app. At the outset of his speech, he proclaimed that all of us are here today and do not want to see, and then again, I cannot repeat this. We will never concede. It doesn't happen. I cannot repeat this. He had then proceeded to allege fraud in various battleground states and to call on Republicans in Congress and Vice President Pence to do the right thing and to send things back to the state. He alleged that there had been fraud on a scale never seen before and detailed at length allegations of this in several battleground states that were won by Biden. He urged that we're going to have to fight much harder and Mike Pence is going to have to come through for us. Throughout his remarks, he enlisted his supporters in his self-described effort to stop the steal. Near the outset of his speech, he stated that we have come to demand, a different language I cannot say here. Later, he said, another phrase I cannot repeat here. At one point near the end of his speech, he briefly turned from alleging fraud and challenging the certification of this to calling on Congress and the state legislators to quickly pass sweeping reforms. He said that we must stop the steal and then we must ensure that such outrageous things never happen again. And in the latter connection, he listed numerous policy proposals achievable with your help. Many of the proposals concerned the conduct of these things. I apologize. Again, there are certain words that I will get dinged on if I say. We will just skip here. At the close of his remarks, he reiterated something's wrong here, something's really wrong, can't have happened, and we fight like hell, and if you don't fight like hell, you're not going to have a country anymore. He then ended his speech by saying, so we're going to walk down to Pennsylvania Avenue, and we're going to the Capitol, and we're going to try and give the Democrats are hopeless. They're never, I cannot say that word, but we're going to try and give our Republicans, the weak ones, because the strong ones don't need any of our help, and we're going to try and give them the kind of pride and boldness that they need to take back our country. So let's walk down to Pennsylvania Avenue. I want to thank you all. God bless you and God bless America. End quote. By 12:53 p.m., as Trump was still speaking at the Ellipse, a crowd formed at the Capitol, and members of the crowd broke through the outer security barriers. They were soon joined by people who had made their way from the Ellipse to the Capitol after President Trump finished his speech. Trump returned to the White House, where he watched television coverage of the events unfolding at the Capitol. Members of the crowd overcame Capitol police officers, some of whom were injured while defending the Capitol from the rioters' advance. Among those injured was plaintiff Sidney Hemby, who was crushed against doors on the east side of the Capitol, struck with fists and various objects, and sprayed with chemicals. After rioters went inside the building, Capitol Police announced a full lockdown of the Capitol, and both houses of Congress stopped counting these and called recesses. At 2:24 p.m., shortly after his supporters breached the Capitol, he tweeted, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts, not these or inaccurate ones which they were asked previously to certify. USA demands the truth. 14 minutes later, he added, please support our Capitol Police and law enforcement. They are truly on the side of our country. Stay peaceful. Inside the Capitol, some lawmakers, including some of the plaintiffs in these cases, became trapped inside the chambers as rioters advanced. Capitol police officers held off rioters by this, deployed this, and told the trapped lawmakers to put on gas masks. One floor below, in the Capitol crypt, a group of Capitol police officers, including plaintiff James Blessingame, attempted to fend off another group of rioters. The rioters struck Officer Blessingame with fists and weapons and subjected him to racial epithets and threats. At 4:17 p.m., he posted on Twitter a recorded video statement in which he directed the rioters to go home. He also repeated his claim of this: "I know you're in pain. I know you're hurt. We love you. You're very special." And at 6:01 p.m., after Capitol Police began clearing the building, he tweeted, "These are the things and events that happen when a sacred landslide thing is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long. Go home with love and in peace. Remember this day forever." The riot resulted in injuries to 140 police officers and claimed several lives. 2 weeks later, on January 20th, then President-elect Biden and then Vice President-elect Harris took office. Sub B, Sub 1. The three cases consolidated in this appeal involve complaints brought against Trump and others in connection with January 6th. The plaintiffs are Capitol police officers and members of Congress who were at the Capitol that day. They seek recovery for physical injuries and emotional distress arising from the riot. As relief, they ask for damages and other remedies, including from Trump. The plaintiffs sue Trump in his personal capacity. Each of the complaints alleges that all his conduct inciting his followers, as described in the complaints, was conducted in his personal capacity as a candidate for elected office, not in any official capacity as president. For example, one complaint elaborates Trump tweeted from his personal account and not from the official White House Twitter account, and spoke at the January 6th rally in his capacity as a losing candidate for the presidency. Each of the complaints asserts a claim about Trump under 42 U.S.C. 1985, which prohibits conspiring to prevent anyone from holding a federal office or from performing the duties of federal office. The Section 1985 claims are generally based on the contention that Trump engaged with others in a plan to prevent Congress from discharging its duties, to count this, and to prevent then Biden and then Harris from assuming office. Two of the complaints include various claims against Trump under District of Columbia law, and one of the complaints contains a claim against Trump under 42 U.S.C. 1986 for failing to stop the riot after it started. Trump moved to dismiss the claims against him on various grounds. Of principal relevance, he argued that he's entitled to official act immunity under Nixon v. Fitzgerald as to all the claims against him. The district court largely rejected Trump's claims of immunity. It reasoned that Trump's alleged acts, his tweets, alleged fraud in this, his efforts to persuade state and local officials to change outcomes, his lawsuits challenging the results, his participation in planning the January 6th rally, and his speech at the rally were aimed at remaining in office for a second term, which to the court was not an official function of this office. The court, however, granted Trump immunity as to the claim under 42 U.S.C. 1986 for failing to stop the riot. The claim the courts held sought to hold Trump liable for failing to exercise his official powers and so fell within his official act immunity. Beyond asserting official act immunity, Trump also sought dismissal of the claims against him on the ground that they seek to hold him liable for speech protected by the First Amendment. The district court rejected that argument. The court held that Trump's speech at the January 6th rally lay beyond the protection of the First Amendment because it amounted to incitement of imminent lawless action, citing Brandenburg. Trump did not attempt to appeal the district court's denial of his First Amendment defense at this stage. His potential entitlement to dismissal on First Amendment grounds is not before us in this appeal. The district court dismissed several of the claims brought under the District of Columbia law as inadequately pleaded on the merits, but it held that the plaintiffs had plausibly alleged that Trump had violated Section 1985 and so allowed the Section 1985 claims against Trump to proceed. And the court reached the same conclusion as to some of the claims under District of Columbia law. Those claims against Trump thus remain live and await resolution. Trump appeals the district court's denial of his claim of official act immunity. That is the sole issue before us. While the denial of a motion to dismiss ordinarily is not immediately appealable, an order denying a claim of official immunity is an immediately appealable collateral order. In considering Trump's claim of immunity, we review the district court's legal determination de novo and assume the truth of the plaintiff's material factual allegations. The Supreme Court's decision in Nixon v. Fitzgerald and Clinton v. Jones established the basic framework for our analysis. In Nixon, A. Ernest Fitzgerald sought civil damages from President Richard M. Nixon and other officials for allegedly eliminating his job at the Department of the Air Force in retaliation for unflattering congressional testimony he had provided about his superiors. The court concluded that President Nixon, as a former president of the United States, was entitled to absolute immunity from damages liability predicated on his official acts. Such immunity, the court said, is a functionally mandated incident of the president's unique office rooted in the constitutional tradition of the separation of powers and supported by our history. This particular kind of immunity doctrine articulated in Nixon is capacious by design. In pre-Nixon official immunity cases involving other officials, the court had employed a functional approach, under which, for most officials, the scope of the immunity defense varied in proportion to the nature of the official's official function and the range of decisions that conceivably might be undertaken in good faith. But the president in the Nixon court explained occupies a unique position in the constitutional scheme. As the embodiment of the executive branch, he must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. The principal rationale for official immunity, providing an official the maximum ability to deal fearlessly and impartially with the duties of his office, thus applies to the president with pronounced force. For that reason, the court found it appropriate to recognize absolute presidential immunity from damages liability for acts within the outer perimeter of his official responsibility. The decisions from which Nixon drew the outer perimeter test make evident that a president's official responsibilities encompass more than just those acts falling within the office's express constitutional and statutory authority. Official responsibilities also include discretionary acts. Within the concept of duty associated with the office. Put somewhat differently, an act lies within the outer perimeter of an official's duties if it is the kind of act not manifestly or palpably beyond the official's authority, but rather having more or less connection with the general matters committed by law to his control or supervision. Applying the outer perimeter test to President Nixon's alleged conduct, the Nixon court had little trouble holding that Nixon was entitled to official immunity. Nixon, the court reasoned, had the constitutional and statutory authority to prescribe the manner in which the Secretary will conduct the business of the Air Force, including by prescribing reorganizations and reductions in force. The court reached that conclusion notwithstanding Fitzgerald's contentions that his dismissal had been retaliatory and that no federal official could, within the outer perimeter of his duties of office, dismiss Fitzgerald without satisfying the applicable for-cause removal standard in prescribed statutory proceedings. Denying immunity on those grounds, the court explained, would require a highly intrusive examination of the president's motives and subject the president to trial on virtually every allegation that an action was unlawful or was taken for a forbidden purpose. Doing so would therefore deprive absolute immunity of its intended effect. The court revisited a president's official act immunity 15 years later in Clinton, its most recent case on the subject. And for those of you who were with me during my reading of this earlier, we are now where I had to stop last time. So we will pick up here. In that case, Paula Jones sought civil damages from President Clinton. She alleged that Clinton, while serving as governor of Arkansas, had made unwelcome advances towards her, and then retaliated against and later defamed her for rejecting his advances. Clinton moved to dismiss, arguing that as president he was entitled to temporary immunity from the lawsuit until after his presidency. The court disagreed, reasoning that Clinton's alleged actions, with the potential exception of allegedly defamatory statements made after he became president, were unrelated to any of his official duties as president of the United States, and indeed occurred before he was elected to that office. Clinton confirmed that the absolute presidential immunity recognized in Nixon is an official immunity that extends no further than the outer perimeter of a president's official responsibility. That is because the primary justification for affording the Presidential Official Act immunity from civil damages liability, enabling him to perform his designated functions effectively without fear that a particular decision may give rise to personal liability, provides no support for an immunity of unofficial conduct. To the contrary, an immunity for unofficial acts would be grounded purely in the identity of the president's office, contravening the settled understanding that immunity is based on the nature of the function performed, not the identity of the actor who performed it. Because Jones's allegations involved Clinton's purely private acts rather than acts taken in his public character, he was not entitled to official immunity, even on a temporary basis. Together, Nixon and Clinton established three governing principles. First, the president is entitled to official immunity from civil damages liability based on actions within the outer perimeter of official presidential responsibility, including discretionary acts within the concept of duty associated with the presidency. Second, the president is subject to civil damages suits based on actions taken in an unofficial private capacity to the same extent as any other private citizen. And third, the president's actions do not fall beyond the outer perimeter of official responsibility merely because they are unlawful or taken for a forbidden purpose. Rather, the president's official immunity insulates all of his official actions from civil damages liabilities, regardless of their legality or his motives. Trump maintains that his actions as alleged in the complaints fall within the outer perimeter of official presidential responsibility, entitling him to official act immunity as to all the claims against him. His primary argument is that his alleged actions leading up to and on January 6th were official presidential actions because they amounted to speech on matters of public concern. In the alternative, he submits that those actions were official because they came within his constitutional duty under the take care clauses. We are unpersuaded by either argument. We begin with Trump's principal contention that a president enjoys absolute immunity from civil damages liability whenever he speaks on matters of public concern. Without reaching the question of whether all President Trump's pertinent actions alleged in the complaints in fact involve speech on matters of public concern, we reject his submission that such speech invariably counts as official activity. To endorse that argument would be to establish an immunity from suit for unofficial acts grounded purely in the identity of the president's office. Make sure I'm in frame here, everybody. The salient question in the cases before us is whether President Trump took the actions alleged in the complaints in his official capacity, or instead in his private capacity. The question whether those actions involve speech on matters of public concern bears no inherent connection to the essential distinction between official and unofficial acts. The most basic premise of Trump's argument that speaking on matters of public concern is something presidents regularly do in the exercise of an official responsibilities is incontestable. principle. The President of the United States possesses an extraordinary power to speak to his fellow citizens and on their behalf. That power, famously labeled the presidential bully pulpit by Theodore Roosevelt, is an everyday tool of the presidency, and many uses of the presidential bully pulpit fall comfortably within the outer perimeter of the president's official responsibility. True, there is no bully pulpit clause in the Constitution, but as we have explained, the outer perimeter of official responsibility extends beyond a president's expressly enumerated powers to encompass discretionary acts within the concept of duty associated with the office. The president thus acts within the outer perimeter of his official functions when he announces his intention to issue an executive order, eulogizes the fallen leader of an ally, or offers the nation's condolences and support in community reeling from a tragedy. Trump's argument, though, reaches considerably further. He insists that all of President's speech on the matters of public concern as a categorical rule is an exercise of official presidential responsibility. That is a sweeping proposition and one that ultimately sweeps too far. The notion that speech must relate to a matter of public concern does not rule out much when the speaker is the president. In view of the visibility of his office and the effect of his actions on countless people, a great deal of what the president does or speaks about becomes a matter of public concern merely by virtue of the identity of his office, even if it would not amount to a matter of public concern if performed or said by someone else. To see how far a public concern test reaches, consider initially an example involving conduct alone rather than speech, in particular, misconduct. Such conduct, as Trump concedes, is presumably of a manifestly private nature, undertaken in a private, unofficial capacity. Yet, alleged misconduct involving the president is also plainly a subject of legitimate news interest. That is, a subject of general interest and of value and concern to the public. To immunize a president from civil damages liability for alleged misconduct during his presidency just because the conduct is a matter of public concern then would be to construct an immunity from suit for unofficial acts grounded purely in the identity of his office. Trump's proposed public concern test would unduly broaden official act immunity in much the same way for presidential speech. The Supreme Court has never suggested that the president has an immunity that extends beyond the scope of any actions taken in an official capacity. President Trump's public concern standard, though, would do just that. When the speaker is the president, speech undertaken in a plainly and purely unofficial capacity will often involve a matter of public concern. Yet Trump's test would still grant immunity in that circumstance, even though there is no support for an immunity for unofficial conduct or speech. As an example, consider a situation directly germane to the cases before us, in which Trump publicly volunteered that he was acting and speaking in an unofficial private capacity. In the period after the 2020 and before January 6th, the Supreme Court considered an effort by Texas to challenge the administration of the election in several battleground states in which then President-elect Biden had been declared the winner. Trump moved to intervene in the case. In doing so, he specifically explained to the Supreme Court and captioned his filing accordingly that he sought to intervene in this matter in his personal capacity as a candidate for re-election to the office of President of the United States. Citing his motion here. He relatively elaborated that he wished to intervene to protect his unique and substantial personal interests as a candidate for re-election to the office of president. Trump then affirmatively communicated to the Supreme Court and the public that he was acting and speaking in that matter in his personal capacity as a candidate for re-election. Indeed, he explained that his reason for wanting to participate in the case was a substantial personal one rather than an official one. That stands in sharp contrast with the other cases in which he, like all presidents, had filed briefs in the Supreme Court in his official capacity as President of the United States. But while Trump's efforts to participate in Texas v. Pennsylvania was made in an expressly and self-consciously personal unofficial capacity, the context of his speech in his submission undoubtedly involved a matter of significant public concern, his challenge to the results in various pivotal states whose electors would determine the outcome of the election. As that example illustrates, an immunity for all presidential speech on matters of public concern without regard to the context in which the president speaks would be grounded purely in the identity of the actor who performed it, rather than the nature of the function performed. Such a result is unsupported by precedent, and it is unsupported by the basic object of granting a president official act immunity, assuring that the president is not unduly cautious in the discharge of his official duties. That concern necessarily has no salience when the president acts by his own admission in an unofficial private capacity. As Trump's intervention motion in Texas v. Pennsylvania highlights, whether the president speaks or engages in conduct on a matter of public concern bears no necessary correlation with whether he speaks or engages in conduct in his official or personal capacity. And because it is the latter question that governs the availability of presidential immunity as a matter both of precedent and of the essential nature of an immunity for and only for official acts, we must reject Trump's proposed public concern test as ill-suited to the inquiry. Trump's intervention motion is telling in a related respect as well, which pertains to identifying when a president acts in an official or private capacity in the specific circumstances of the cases before us. The motion expressly recognizes, as we hold today, that when a sitting president acts as a candidate for re-election, he does so in his personal capacity, not in an official capacity. Otherwise said, a sitting president, just like the candidates he runs with, is subject to civil damages liability for his actions constituting re-election campaign activity. The principle that an incumbent president seeks a re-election in his private capacity rather than in his official capacity finds its roots in the framing. Madison explained that a dependence on the people is no doubt the primary control on the government. Citing Federalist number 51. To that end, the framers rendered the president directly accountable to the people through regular elections, and every practical obstacle was imposed to prevent cabal, intrigue, and corruption from giving an incumbent president a structural electoral advantage, including the exclusion from service in the Electoral College of all those who, from situation, might be suspected of too great devotion to the president in office. Citing Federalist number 68 by Alexander Hamilton. The essence of those framing era principles, in the words of Chief Justice Marshall, is that the president is elected from the mass of the people, and on the expiration of the time for which he is elected, returns to the mass of people again. Quoting U.S. v. Burr, 1807. That fundamental understanding holds regardless of whether that person elected to serve as the next president also happens to be the incumbent. A sitting president has no inherently greater claim to serving the next four-year term than does any other candidate. And if an incumbent president seeks and ultimately wins re-election, he does so in the same manner as anyone else vying for the office. He is elected from the mass of people. It follows that when a sitting president acts in his capacity as a candidate for re-election, he acts as an office seeker, not an office holder. The presidency itself has no institutional interest in who will occupy the office next. Campaigning to attain that office, thus, is not an official function of the office. Rather, an incumbent president's interest in winning re-election have the same purely private character as those of his challengers, substantial personal interest as a candidate to attain or retain the office. Accordingly, a president acts in a private, unofficial capacity when engaged in re-election campaign activity. The executive branch's own views and practice reinforce this point. In 1982, just a few months before the Supreme Court decided Nixon, the Department of Justice's Office of Legal Counsel advised President Reagan that funds appropriated to the official functioning of the offices of the President and Vice President may be used for travel expenses only if the travel is reasonably related to an official purpose, and that appropriated funds thus should not be used to pay for political events. Payment of expenses associated with travel by the President and Vice President cited here. Political events, they reasoned, generally have no reasonable connection to the official purposes served by appropriated funds. As a general rule, moreover, President and Vice Presidential travel should be considered political if its primary purpose involves their positions as leaders of their political party, as would be the case with appearing at party functions, fundraising, and campaigning for specific candidates, of course, including for oneself. The executive branch itself thus considers its own chief office holder's campaign for re-election to lie well outside of his official functions. A contrary conclusion would grant a sitting president immunity based purely in the identity of his office, improperly treating his efforts to gain the office for a second term as an official act of the office. Compare, for instance, the former one-term president who runs to regain the presidency for a second, non-consecutive term with a current one-term president who runs to retain office for a second straight term. Whether one-term president runs to regain the office or to retain it, the object is the same, to serve again as president in the next term. And with respect to their campaign-related activity to attain that objective, there is no basis for cloaking a sitting president running for the office with an immunity and resulting advantage that a former president running for the office would lack. Both act in their personal capacity as a candidate for re-election to the office of president. Trump's proposed public concern standard, though, would treat them differently. The sitting president would enjoy absolute immunity for all speech on all matter of public concern, even purely campaign speech, given strictly in his capacity as candidate, whereas the former president would get immunity for precisely the same campaign speech. Pausing just for a quick tea break, everybody. Consider, for example, a speech at a political party's convention accepting the party's nomination as its candidate for president. Such a speech is inherently given in the nominee's private capacity as office seeker. That is no less true when the party's nominee is the sitting president. A sitting president gives the acceptance speech at his party's convention only if he seeks and wins the party's nomination, or else some other person will give the same speech. In that situation, then, the president speaks in an unofficial private capacity, applying the executive branch's long-time understanding. If a sitting president running for re-election gives an acceptance speech at a party's convention, then presumably counts as a speech at the party's convention presumably counts as appearing at a party function and is unofficial activity in the executive branch's own views. But because an acceptance speech at a party convention will also surely address matters of public concern, Trump's proposed approach would nonetheless grant a sitting president immunity for it. The former president, though, would not get the same favorable treatment for the same speech, nor would any other candidate. Trump's approach, thus, would attach official act immunity to an unofficial conduct of an individual who happens to be president. Or take another example, a campaign ad fully funded by a candidate's campaign, her authorized political committee in the words of campaign finance law. In the ad, the candidate discusses her policy priorities, no doubt matters of public concern, and the ad concludes with the legally mandated disclosure paid for and authorized by Jane Doe's campaign, followed by the familiar voiceover, "I am Jane Doe and I approve this message." Under President Trump's proposed public concerns test if the candidate happens to be the sitting president, but not if she's a former president or any other candidate, her speech in the ad would be official, even though it's plainly campaign speech in a campaign ad given in her private capacity as candidate. A sitting president, then, would be absolutely immune from defamation liability for something she may have said about her opponent in the campaign ad, whereas a former president would face liability for saying the very same thing in the very same ad. The pro-incumbent imbalance would be especially stark if the former and current presidents were to run against each other. In that situation, one candidate, the former president, would face civil damages liability for statements on matters of public concern in a campaign ads or in an acceptance speech at the party convention. But the competing candidate, the sitting president, would be wholly insulated from damages liability for making the very same statements on the opposing side of the very same race. We see no basis for giving an incumbent president that kind of asymmetrical advantage when running against his predecessor. That is not to say that when an incumbent president engages in campaign speech as a candidate, there's no recognition of his current office. At the party conventions, he presumably would be introduced and referred to as the president, as is natural. And relatedly, he may give the acceptance speech at a podium affixed with the presidential seal, as nominees of both major political parties have done when speaking in their private capacities as candidates for re-election. But while the person giving the address is and is recognized to be the sitting president, he still delivers the address in his private, unofficial capacity as candidate for re-election. It is analogous to the president appearing in a public filing as the president of the United States, but specifically in his personal capacity as a candidate for re-election. And when the president speaks strictly in that capacity, there is no warrant for granting him official act immunity. In short, a president's speech on matters of public concern can be an official act, as in the case of the State of the Union address, or an unofficial act, as in the case of a speech at a re-election campaign rally. For purposes of presidential immunity, the key is whether the president is speaking or engaging in conduct in an official capacity as an office holder, or instead in an unofficial capacity as an office seeker. Whether the speech relates to matters of public concern is besides the point. Because Trump believes that speech on matters of public concern constitutes official presidential action as a categorical matter, he makes no effort in this appeal to resist the notion that he was acting in his capacity as a candidate when engaged in the activity alleged in the complaints. In his view, he's entitled to immunity regardless of whether he was acting as a candidate. Even if so, Trump submits his relevant actions in the run-up to January 6th and on the day itself amounted to speech on a matter of public concern, the integrity of the 2020 election, and so fell well within the scope of ordinary presidential action, entitled to immunity. As Trump would have it then, he engaged in official presidential action for immunity purposes, even when he, by his own description, acted and spoke in his personal capacity as a candidate for re-election, rather than in his official capacity as president. We're citing briefs here. After all, his arguments in that filing addressed at length the same matter of public concern that he invokes in this appeal, the integrity of the 2020 election. But as the Supreme Court explained, there is no support for an immunity for unofficial conduct, and hence no basis for granting immunity for conduct or speech the president himself contemporaneously recognizes he undertakes in his personal unofficial capacity as a candidate. C. Under Nixon and Clinton, then, the task is to distinguish between official acts and private acts. In the context of the cases before us, that means determining whether Trump acted as an office holder, office seeker, when he engaged in the activity alleged in the complaints. In that regard, we recognize that there is not always a clear line between the president's personal and official affairs. In particular, the line between president and candidate will not always be clear. But in some situations, there will be little doubt, and not just when the president himself allows that he acts in his personal capacity as a candidate for re-election. When a sitting president solicits donations at a fundraiser for his re-election campaign, fires a campaign pollster, or hires a new one, or gives a speech at a party convention accepting the party's nomination, it is straightforward to conclude that he acts in an unofficial capacity as a presidential candidate rather than an official capacity as an incumbent president. Even if other contexts doubtless present closer calls, there is ultimately no avoiding the essential understanding that a president's immunity from damages liability applies only to acts within the outer perimeter of his official responsibilities, citing Nixon, and hence does not extend beyond the scope of any actions taken in an official capacity, citing Clinton. The potential difficulty of meeting out of the distinction in some situations then cannot justify simply giving up on the enterprise altogether, and Trump himself allows that courts can, in fact, tell the difference between official and unofficial conduct, citing Trump's reply brief. The inquiry, though, should be fashioned and carried out with appropriate sensitivity to the important interests at stake. In that connection, the Supreme Court has emphasized the need to avoid highly intrusive inquiries into the president's motives. An assessment of whether the president's engaged in an official function or unofficial re-election campaign activity correspondingly does not turn on whether the activity was subjectively undertaken in some measure to enhance the president's re-election prospects or profile. The inquiry, instead, is an objective one, grounded in the context-specific assessment of the nature of the function performed, citing Clinton. We emphasize context because only by looking to the context can the relevant nature of an action be understood. The same essential message or act may be either official or unofficial, depending on the circumstances in which it is delivered or performed. The president's delivery of the State of the Union address to Congress and the public, for instance, is an official act. That remains so regardless of whether he may draw themes and make points with an eye on maintaining his public standing in an election year, or whether priorities given primacy in the speech may echo ones emphasized on the campaign trail. Conversely, a speech at a campaign rally, fully funded by a president's campaign committee, might relate some of the same messages as the State of the Union address, but is an unofficial event by nature. Similarly, the president can remove the Secretary of State and he can remove his campaign manager. The former is an official exercise of the executive power, but the latter is no such thing. Understanding the context, then, will often be essential to identifying the capacity in which a president acts. That context may be substantially informed by the way in which the president and the executive branch themselves treat the activity in question. If it is clothed in the trappings of an official function based on objective indicia, it more likely constitutes an official act for immunity purposes than if it bears the hallmarks of re-election campaign activity. So, if an activity is organized and promoted by official White House channels and the government officials and funded with public resources, it's more likely an official presidential undertaking than if it is organized, promoted, and funded by campaign channels, personnel, and resources. Those considerations may not always point in the same direction or even be known, but they may be illuminating when brought to light. The grant of immunity aims to free the president from an inclination that may otherwise exist to discharge his official functions in an unduly cautious manner. Yet if the president's and executive branch's own treatment of the matter exhibits that he views himself to be engaged in a private activity as a candidate, there's no cognizable public interest in assuring he can carry out the quintessentially unofficial function with boldness. When an appropriately objective context-specific assessment yields no sufficiently clear answer to either direction, the president, in our view, should be afforded immunity. The special nature of the president's constitutional office and functions prompted the Nixon court to extend immunity to outer perimeter of his official responsibility, and subsequent decisions have construed statutes not to constrain presidential action absent clear indications of Congress's intent to do so. The same consideration counsel in favor of construing the president's actions to involve official functions so long as they can reasonably be understood as such, citing Hawaii. Conversely, though, when a president's actions viewed objectively and in the context may reasonably be understood only as re-election campaign activity, a court not only may but must deny immunity. By doing so, the court acts not in derogation of the separation of powers, but to maintain their proper balance. We have no occasion to apply that framework in this appeal because, as explained, Trump makes no argument at this stage that his actions, as alleged in the complaints, were not re-election campaign activity. He will have every opportunity to make such an argument in the proceedings to come in the district court, but the inquiry we have outlined is consistent with his submission that the analysis should turn on the function being performed, not the politics or policy being advanced or the words being used, and the inquiry does not consist of trying to identify speech that would benefit a president politically. That is not to say that the content of a speech will invariably be entirely off limits. In certain circumstances, for instance, it could serve to confirm what an objective assessment of the context makes evident. Indeed, even deciding whether speech is of public or private concern under Trump's proposed approach would require us to examine the content, form, and the context of the speech. But the crux of the inquiry we have described concerns the context in which the president speaks, not what precisely he says or whether it might advance his re-election prospects. By the way of illustration, consider Trump's speech at the Salute to America event on the National Mall on July 4th of 2019. By the time of the address, Trump had formally announced his candidacy for re-election. And we're citing sources here, and his address drew criticism in many quarters as amounting to taxpayer-funded campaign rally in service to his re-election effort. But several objective considerations strongly suggest that the speech was treated by the president and executive branch as part of an official event, regardless of whether what was said or how it was conceived might have been borne some subjective connection to enhancing Trump's re-election prospects. For instance, the Salute to America rally was publicly funded, including through National Park Service and Department of Defense resources. In addition, the government promoted the event, and its primary organizers were government officials from the White House and the Department of the Interior. The National Park Service, for example, presented the event and invited the people to attend, citing multiple sources here. Accordingly, the White House treated President Trump's speech as official presidential remarks on its official website, and while Trump was in office, dedicated a website to the annual Salute to America event. In multiple citations here of different White House sightings. So we've got the White House archived. The White House also promoted the event on its official Twitter account. And finally, a number of government officials attended the event, as was noted in the presidential remarks, some of whom could have violated federal law by attending it if it were a campaign event. We have no need here to definitively decide whether Trump's remarks at the Salute to America event will qualify as official presidential action for purposes of presidential immunity. Additional considerations might affect the assessment in some fashion. As one example, if the White House's official Twitter feed regularly promoted quintessential campaign events, its promotion of the Salute to America rally may not itself shed material light on the event's official or unofficial character in the eyes of the executive branch. but at the event would be treated as official action if it could be reasonably be understood in that way. Whether his remarks addressed matters of public concern would not, and we believe should not, decide the issue. We turn next to President Trump's alternative argument that he's entitled to official act immunity because he took the actions alleged in the complaints in an exercise of his Article 2 duty, take care that the laws be faithfully executed. Trump's contention in that regard, however, does not demonstrate that he was acting in his official capacity so much as presume it. His argument presents no ground for affording him immunity that is independent of his ability to show that he engaged in the relevant actions in his official capacity as president, rather than in his private capacity as presidential candidate. The duty and authority to ensure the faithful execution of the laws, as with all the executive power, is vested in the president solely in his official capacity, citing U.S. Constitution, Article 1, Section 1, Clause 1. After all, the president assumes his Take Care Clause responsibilities and other executive duties only upon taking the constitutional oath of office, in which he must solemnly swear that he will faithfully execute the office of the President of the United States. Nothing in Article 2 contemplates the president's exercise of the powers of the presidency when acting in private, i.e., non-presidential capacity. Rather, Trump's assertion that he exercised his authority under the Take Care Clause, at least without more, assumes the answer to the question whether he acted in an official capacity as an office holder or in a private capacity as office seeker. If he acted in the latter capacity, he cannot have been exercising the duties of the very office he was seeking to attain, any more than could his challengers when taking the same kinds of actions in seeking to attain the same office. It is not that Trump could not establish his entitlement to immunity by demonstrating that he acted pursuant to the Take Care Clause. It is that he has not done so. He asserts He asserts that he was attempting to ensure faithful execution of the laws, in particular the Electoral Count Act, but he has not explained why his actions should count as official other than to say they fit within the ambit of his Take Care Clause duties. They might or they might not, depending on the context in which he acted. The president could exhort Congress to do its duty under the Electoral Count Act in a campaign ad, or he could do the same in the State of the Union address, even assuming without deciding that the latter would be an action taken in furtherance of the president's Take Care Clause duties. The former would not be, and indeed could not be, given that, as explained, the Take Care Clause presupposes official rather than private action. Trump, though, has made no argument as to why his actions alleged here should be treated more like the State of the Union than the campaign ad. His invocation of the Take Care Clause thus ultimately does not add anything to his claim of immunity in the circumstances of the cases before us. Sub C. Whereas President Trump propounds a theory of immunity that, in application, could confer immunity even if he acted in an unofficial capacity as presidential candidate, the plaintiff's theory presents the opposite shortcoming. It could deny a president immunity even if he acted in his official capacity as sitting president. The government's proposed approach ultimately shares that same deficiency. We thus decline to adopt either the plaintiff's or government's proposed rationales for rejecting Trump's claim of immunity. The plaintiffs argue that a president's official responsibility do not include engaging in campaign activity. That reasoning, consistent with the approach we have outlined, focuses on whether the president acted in his official capacity as an incumbent office holder or instead engaged in campaign activity in his private capacity as office seeker. To that extent, we agree with the plaintiffs' understanding of the pertinent inquiry in the cases before us. But the plaintiffs also go further. In their view, Trump's actions were not official activity and thus are not imbued with immunity because they obstructed a constitutional process in which his office had no role, thereby infringing on the separation of powers. The plaintiffs maintain that the constitutional intentionality excludes the president from the formal process of counting electoral votes, assigning the function instead to Congress and the vice president in his capacity as president of the Senate. Trump's alleged efforts to interfere in that process, the plaintiffs assert, thus necessarily fell beyond the outer perimeter of his official presidential duties, and indeed undermined the democratic legitimacy of the presidency. As a result, the plaintiffs urged Trump's claim of immunity must be denied. That argument, in our view, cannot carry the day. Nixon's outer perimeter test, as we have explained, does not confine the president's official act immunity to actions the Constitution expressly authorizes him to take. We do not doubt, for instance, that the president can act in an official capacity when commenting on state legislation, on a judicial decision, or on Congress's internal procedures, even though those matters may lie beyond the president's own enumerated job duties. To be sure, if the president speaks about those subjects at a re-election campaign rally, he does so in an unofficial capacity, but that is because he acts in his private capacity as presidential candidate, not because he engages with matters falling outside his enumerated executive responsibilities. Here, insofar as the plaintiffs' arguments rest on the notion that Trump's alleged actions infringed on the separation of powers, their reasoning tends on balance to supporting granting immunity more than it does withholding it. The plaintiffs assert that Trump's disruption of the constitutionally mandated separation of powers by invading a coordinate branch of government, i.e. Congress, as it called out its own constitutional duties to count the votes of the Electoral College. That kind of executive branch interference to the plaintiffs works as a blatant violation of the constitutional separation of powers, which restrains each of the three branches of the federal government from encroaching on the domain of the other two. In conceiving Trump's actions as an effort by one branch to interfere in another branch's sphere, however, the plaintiff's argument presupposes that Trump acted in unofficial capacity. He could effect an executive branch incursion on a coordinate branch only if he were acting in his capacity as the executive branch chief officer, in his official capacity as president. Put in the alternative, he could not work an executive branch intrusion on another branch's domain if he were acting in an unofficial private capacity. In that event, he would be acting as a private person, lacking any authority over the executive branch, not as the branch's chief officer. In short, the president acts in an official capacity cloaked with the protections of immunity when he allegedly perpetuates an infringement of the separation of powers, but he lacks any ability to violate the separation of powers when acting in the kind of private, unofficial capacity for which immunity is unavailable. By way of illustration, consider perhaps the most dramatic example of a president found to have exceeded the executive branch's authority in a manner encroaching on Congress's domain. Citing Clinton discussing the Youngstown Sheet and Tube Company case. Youngstown Sheet and Tube Company v. Sawyer involved a challenge to President Truman's executive order directing the Secretary of Commerce to seize and operate the nation's steel mills at the height of the Korean War. The Supreme Court rejected that assertion of presidential power, holding that the founders of this nation entrusted the lawmaking power to Congress alone in both good and bad times. But while President Truman was found to have gone beyond the limits of his branch's authority into the province of the of a coordinate branch, he did so in an exercise of official responsibility as to which immunity from civil damages liability would attach. Indeed, the Supreme Court, in the course of later days, denying immunity to President Clinton, described President Truman's challenged order in Youngstown as an example of when the president takes official action. So, whereas the Supreme Court would treat Truman's act as official even though it encroached on the coordinate branch's domains, the plaintiff's approach would treat it as unofficial and, if follows, unprotected by official act immunity in a civil damages suit. The plaintiffs might perceive Youngstown as different from this case on a theory that Trump affirmatively obstructed Congress, something Truman did not do, but the Youngstown framework treats all presidential actions interfering with the express or implied will of Congress the same, as falling as the lowest ebb of a president's authority, but still fully eligible for treatment as official action for purposes of presidential immunity. And we see no reliable administratable criteria for the predictably identifying when the presidential action might amount to obstruction of a coordinate branch as opposed to something less. That is particularly so when, as here, the extent to which a president's challenged actions ultimately interfere with a coordinate branch depends on how third parties respond to the president, insofar as those kinds of third-party reactions may be difficult to predict, as could well be the case in the charged context in which presidential immunity can be an issue. A president might hesitate to act with the conviction and dispatch that official act immunity aims to secure. Under the plaintiff's theory, moreover, the availability of presidential official act immunity would turn on the legality of the president's actions, specifically on whether the actions flouted in the separation of powers by intruding on a coordinate branch. But Nixon forecloses a legality-centered approach of that sort. Recall that the Supreme Court rejected the suggestion that because President Nixon had unlawfully discharged Fitzgerald without adequate cause, he had necessarily acted beyond the outer perimeter of his official function. Withholding immunity on that basis, the court explained, would subject the president to trial on virtually every allegation that an action was unlawful, which in turn would deprive absolute immunity of its intended effect. Those concerns apply to an alleged violation of the separation of powers no less than any other alleged violation of law. In fact, the more uncertain the lawfulness of the prospective official action, the more pronounced the need for the need for an effective granting official act immunity. On the register, immunity for separation of powers violations rates quite high, for the lines between the powers of the three branches are not always neatly defined. For that reason as well, we are unmoved by the plaintiff's argument for a denial of immunity based on Trump's ostensible infringement of the separation of powers. Sub 2. Like the plaintiffs, the government puts forward an argument for affirming the denial of immunity to Trump that does not adequately correlate with whether he took the actions alleged in the complaints in his official capacity as president or in his private capacity as presidential candidate. In fact, the central object of the government's proposed approach is to avoid the need to apply that distinction. We appreciate the government's submission of its views in response to our invitation to share the executive branch's perspective on the proper resolution of this appeal, but we decline to adopt the government's suggested approach. The government's proposed approach is highly fact-specific, turning on the particular grounds advanced and not advanced by Trump on appeal. The government seizes on Trump's argument that speech on matters of public concern as a categorical matter is an official presidential function. That argument, the government reasons, assumes that a president would be afforded immunity even if his speech amounts to incitement of imminent private violence. The government proposes that we reject Trump's argument for immunity by exploiting that assumption, because in the government's view, Incitement of imminent private violence, by definition, lies outside the president's official functions, and the government suggests that we simply assume that Trump's conduct fits within that category of ostensibly non-immune activity, the boundaries of which the government would define by reference to First Amendment standards marking unprotected incitement as set out in Brandenburg versus Ohio. As an initial matter, the government's suggested approach could lead to our denying immunity to President Trump based on an assumption that turns out to be false indeed, an assumption that Trump has already contested. The government asks us to assume for purposes of this appeal, but not actually decide, that Trump's speech on January 6th and in the lead up to that day falls outside the First Amendment's protections because it amounts to incitement of imminent lawless action under Brandenburg. We could so assume only because the First Amendment question is not presented before us, since Trump opted not to seek appellate review on that issue at this time. If his First Amendment claim were before us, we would need to engage it on the merits rather than assume its rejection. The issue, though, remains in the case and could come before us at a later stage. So, if we were to accept the government's suggested approach, we might resolve the question of Trump's immunity based on an assumed answer to his First Amendment claim that perhaps could, depending on its ultimate resolution, the merits of which we do not now assess in any way, fail to stand up in the end. As for the substantive merits of the government's proposed approach, it aligns the scope of the president's official act immunity with the scope protected speech under the First Amendment. There is no evident precedent for that kind of approach, and the fit seems an uneasy one. The considerations that inform whether a president is engaged in the discharge of official duties, the relevant question for purposes of presidential immunity, bear no necessary relation to the consideration that inform whether a president's speech would fall within the First Amendment's protections. The two inquiries serve distinct purposes and, in some sense, appear to work at cross purposes. At a high level, the president is immune when he acts in his official capacity, i.e., as the government rather than in his private person, whereas the First Amendment protects private persons against restraints imposed by the government. It is unclear why the existence of official act immunity's protection for acting as the government should turn on the existence of First Amendment protections against the government. In operation, the government's proposed approach would tend to confer presidential immunity when it is least needed, while withholding it when it is most needed. As to the former, if the president's speech falls within the First Amendment's protections, the government's approach would preserve presidential immunity. But if the First Amendment protects the president's speech, that protection would foreclose the possibility of civil damages based on speech, regardless of presidential immunity, citing the Hustler magazine case. In that situation, the president would have little need for the protection that official act immunity would afford. Conversely, if the president's speech falls outside the First Amendment's protections because it amounts to incitement, the government's proposed approach would leave the president without official act immunity, even if it otherwise seemed apparent that the speech was delivered in an official capacity. And while the government specifically focuses on incitement, there are other types of unprotected speech too, such as defamation. We see no conceptual basis for confining a theory that would render immunity unavailable when the First Amendment is unavailable to one type of unprotected speech alone. So the president would be denied immunity not just for incitement, but also for defamation or other types of unprotected expression. And when the president engages in speech amounting to incitement or defamation, he not only removes himself from the First Amendment's protections, but he also subjects himself to the perspective of damage suits, the situation in which official act immunity is silent. The government would accept that result because it considers incitement and presumably other categories of similarly unprotected speech to be categorically unofficial. But it is possible that a president, in exhorting the public to action on a cause considered essential, or in responding to a reporter's question at the White House press briefing about criticism directed at the president, might speak in a manner testing the potentially indistinct lines dividing protected from unprotected speech. Incitement to disorder, the Supreme Court recently observed, is commonly a hair's breadth away from political advocacy, citing the Counterman case. Also citing Clinton v. Jones, alleging defamation by Mr. Jones' presidential press secretary by Mr. Clinton presidential press secretary while Mr. Clinton was president. The government's suggested approach would deny official act immunity if a president's borderline speech falls on the wrong side of that potentially elusive divide. But immunity cannot serve its intended purpose if it is withheld when a president would need it most, i.e., when a president might refrain from undertaking some course of official action because of uncertainty about whether it could give rise to damages liability. To that end, Nixon, as explained, rejected as unduly constraining the proposition that a president's official act immunity is coextensive with the legality of his actions. Yet, that would be the upshot of an approach that would deny immunity if the president's speech falls beyond the First Amendment's protections. All told, we see no sound basis for the categorically excluding unprotected speech from the protections of presidential official act immunity, and little affirmative reason for doing so. We therefore decline to accept the government's proposed approach. Okay, we are getting now to the final pages, everybody. Section 3. While we affirm the district court's denial of President Trump's claim of official act immunity at the current stage of the proceedings, that does not mean the proceedings now instantly move ahead to engage with the merits of the plaintiff's claims. Trump moved to dismiss the claims against him on grounds of official act immunity based on the allegations in the complaints, and at the motion to dismiss stage, those allegations are assumed to be true. He thus has had no opportunity to dispute the plaintiff's allegations bearing on the immunity question or to introduce his own facts pertaining to the issue. He must be afforded the opportunity before the proceedings can move ahead to the merits, including before any merits-related discovery. Official immunity, including the president's official act immunity, is immunity from suit rather than a mere defense to liability. It is an entitlement not to stand trial or face the other burdens of litigation. And as we have made clear, discovery is itself one of the burdens from which defendants are sheltered by official immunity. The importance of shielding officials from the burden of unwarranted discovery is among the reasons the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. Those concerns are particularly pronounced when the official claiming immunity from suit is the president. While Trump therefore must be afforded an opportunity to resolve his immunity claim before the merits discovery bearing on the immunity question itself might be in order if the circumstances warrant it. The Supreme Court has recognized that discovery tailored specifically to the question of immunity may be merited where there is a need to develop facts or resolve factual disputes to facilitate deciding a threshold question of immunity. Trump may, of course, move for summary judgment on his immunity claim, and the district court may rule on any such motion once the factual record on the issue is sufficiently developed. And we're citing case law here. Oh, okay, let's see here. Where the parties present a factual dispute about the challenged conduct and the merits of the qualified immunity question, turn on that dispute, discovery may be necessary before a motion for summary judgment on qualified immunity grounds can be resolved. At the summary judgment stage and throughout Trump And throughout, Trump bears the burden of establishing that he's entitled to official act immunity. As a general matter, the burden of justifying absolute immunity rests on the official asserting the claim. There is no evident reason to apply any different approach in the context of presidential immunity. In Nixon, the Supreme Court characterized a president's official act immunity as a defense that President Nixon had claimed, and the court nowhere suggested the need for any president-specific exception to the general rule that a defendant must plead and prove a defense. Accordingly, in Jones v. Clinton, the Court of Appeals held that President Clinton bore the burden of establishing his entitlement to presidential immunity, a conclusion the Supreme Court did not address or revisit in its decision on that case. Although Trump may demonstrate his entitlement to immunity, that burden will be met if, based on appropriately objective and context-specific assessment, his alleged actions can reasonably be understood as the official actions of an office holder rather than an unofficial actions of an office seeker. In other words, it is reasonable to think he was exercising his official responsibilities as president, or was he instead engaging in re-election campaign activity as a presidential candidate? The complaints contain factual allegations potentially bearing on the issue. This is the last page, everyone. For instance, that the January 6th rally was organized in part by Trump's former campaign staff and arranged and funded by a small group including a top Trump campaign fundraiser and donor. Trump appears to deny those accounts as factual matters, having asserted in the district court that the Jan 6 rally is in no way related to the campaign. That campaign doesn't pay for it. The campaign is not involved with it. Those sorts of considerations and others would inform the assessment and ultimate resolution of Trump's claim of official act immunity in the proceedings to come in the district court, insofar as he continues to press that defense. As for the appeal presently before us, we affirm the district court's denial of Trump's motion to dismiss on grounds of presidential immunity, and we leave it to that court to conduct further proceedings on the issue as desired and warranted. For the foregoing reasons, we affirm the district court's denial of Trump's motion to dismiss the claims against him on grounds of presidential immunity, so ordered. Now, the following pages after this are concurrence by Judge Katsas and Rogers, and I am not going to read through concurrences as they are not law. So let me go ahead and turn comments on, everybody. We can do a little Q&A after that. So just one moment. Okay, we should be good to go. So welcome, everybody. I'm glad you could join me. A little impromptu. Oh, thank you. Thank you for that. Hello, everybody. Welcome. Thank you, Chris. Yes, we made it through. It was such an important case. I really wanted to give it another try to kind of get through what was going on there. It was a lot. It really was a lot. But I think they were pretty organized with it. Good morning. Yes. Good morning. Yes, that's a wonderful day. Oh, Kristen. Oh my goodness. I'm glad we were able to talk through this one. I had started it earlier this week and had not been able to finish it. So, did you see the video? No, I haven't. I'll have to check on that, Olga. I'm sorry about that. He will not get special treatment. Right. I mean, the whole question here that the court was addressing was his speech on January 6th, in his official capacity as the president or as a presidential candidate. So I think that issue is an important distinction that the court's making. If it was privately done, then there's no immunity. If it was publicly done, then there is immunity. But on the other hand, there are more problems as well. Hypothetical use of a female president. I like that too, Mama Llama. I love that because every time in all of our cases, we keep referring to the president as a him, right? So I thought it was kind of fun that they put a little spin on that. And we've got some amazing judges too out of the District of Columbia circuit. So we've got a lot of good people there. I saw a squirrel. I forgot my question. Oh, Navy, I know. I know. I have to have a little notepad next to me too at all times. For sure, for sure. Yes, so June Marie, yes. Now, my understanding is in about 15 minutes, actually, the Colorado Supreme Court will be listening to arguments today at 1 o'clock Colorado time. Is that Mountain time, everybody? Mountain time. So it should be very interesting. Yes, it was that of a candidate that had lost. I agree. I agree. I think the court kind of interpreted that correctly. I thought it was interesting that they felt the government had missed the boat on that one, and that they had even invited the government to come in and put in what they thought. So, doing the work of the people, thank you. Thank you, Lawrence. Oh, I'm happy to come on and exchange and talk and discuss those kinds of things. Lots of different questions to go through for sure. Yeah, I thought it was interesting. They invited the government to put their 2 cents worth in, and then they said, we disagree, which is how it should be. Okay, MST, Mountain Standard Time. Okay, good. That's good to know. Excellent. Yeah, it should be coming up here pretty soon. So it'll be very interesting to see what happens in Colorado. I think, the judge really set it up. I don't think she could have been any more thorough with her decision at all than what she did. So she did an amazing job with her opinion out of the district court there in Colorado. So we will see what their Supreme Court says. We saw the Minnesota Supreme Court listening to oral arguments. So I'm imagining it would be a bit similar to that, but almost close enough to be Pacific. Yes, I get what happens if he's off the ballot? So if he's off the ballot, sorry, I'm taking a tea break, everybody. Just a minute. So this would only be with regards to Colorado if he was off the ballot. So he would appeal, and then it would just keep appealing until, it's tough because the Colorado Supreme Court's the last stop for state cases. So he would have to put in that somehow a fundamental federal constitutional right is being infringed upon by not having him on the ballot. He would only be pulled off of the Colorado ballot. So that would just mean, whoops. Sorry, everybody. Did I scare you? Whoopsies. Okay, we're back. That would just mean, sorry, everybody. Woo, we're flying. We're flying. That would just mean he would be off of the ballot there in Colorado. So he would be on for the rest of them. Yes, it did hurt. That did hurt, actually. Oh, my goodness, everybody. Yes, ma'am down. That's so funny. Oh, my gosh. Yeah, sorry about that. So, yeah, if Colorado ruled to take him off the ballot, he would only be off the ballot there in the Colorado case, is how that would all work out. I fell over. I know, Deborah. I have a new tripod, everybody. I'm still trying to figure out exactly. It's a little bit different. I'm not quite used to it yet. Open the floodgate for other states. Exactly. It would set that precedent to that. That's exactly it, that it would set the precedent for that. So that would be very exciting to be able to come in and say, well, we've got one Supreme Court that's already said he shouldn't be on the ballot. And so to have that precedent in place would be really good. Could he still be written in on the ballots? Yes, he could. And anybody can be written in on the ballots, anybody at all. So you could put Mickey Mouse, or you could put, whomever you want on the ballots. Sorry, I just got tangled up in my own tripod. If y'all could see me right now, I'm literally tangled up in my tripod. Oh my goodness. Yes. So, sorry about that. Hold on, I'm trying to move my leg. Oh my gosh. Anyway, can they actually be, take your time. The struggle. Oh my gosh, the struggle today, everybody. Okay. Yeah. Well, Mickey Mouse does get a lot. I know. Nothing to see here, everybody. All right. Here, everybody, just give me 1 second. Let me see if I've got to pull my ankle out of the tripod. Just a second. All right, thanks everybody. I was a little uncomfortable there without having full use of my leg. There we go. I'm back. Oh my gosh. Oh, blooper reel. I know. Yeah, I'm sitting on a filing cabinet, and so the tripod fell over. Oh my goodness. True. Sorry about that. Yes, technology, I try. Yes, pay no attention to what's going on behind the curtain. Oh my goodness. All right, I still have my leg. I'm happy. So, never a dull moment. You know, I tell you, with all these bloopers and you all still come and hang out with me, I'm so thankful. Oh my goodness. I'm going to need to start wearing shoes though when I do my lives, I think. Yes, you need to. I know. I need to buy a chair, everybody. For some reason, I'm not sure. I keep looking. I'm like, oh, maybe I'll get one tomorrow. For some reason, I'm just continuing to sit on my filing cabinet. Oh my goodness. I don't know. Oh my gosh. Yes. So I need to I need to get a different chair. But at least everybody's okay. So yeah. It is a magic wand. I've got my whole pen container here, so I have to pick out. Oh my gosh, yes, indeed. I know, I need to go and get one. I do. I just don't seem to, it's just low, it's a low priority for some reason. I think secretly I'm just unwilling to move from my filing cabinet. I think that's part of it. Oh, thanks. Oh my gosh. Yes. So I know I'm alone. I'm sure lots of those professionals. Well, I mean, even, within our world with barrister and legal dad, I never see them falling off of their filing cabinets. Oh my gosh. So that's all right. That's okay. That's a bonus, everybody. That's comic relief. Oh my gosh. Need an affidavit of intent to be counted in Colorado. Oh, excellent point, David. That's a really excellent point, actually. There are qualifications. And if you think, too, the whole point of it is that the popular vote, right? The popular vote determines who gets the electors for the state. So if you've got a write-in candidate, how would it be possible for a write-in candidate to get the majority of the popular vote in Colorado? I mean, that's kind of another way of looking at it. Don't try this in court. True story. Oh my goodness. Oh my goodness. Oh my gosh. Oh, the stories. Yes. There have been some stories. Oh my gosh. It took a whole year. No, it won't. See, I think it's going to go quick from this point on because, the district court, it took such a long time because there were all the witnesses and all the testimony, but we're just reviewing, the Supreme Court in Colorado is just reviewing the district court's decision. So it's paperwork and it's oral arguments. So I have a feeling they've probably already had a pretty good idea of which way they're going to rule even before those oral arguments. So, typically you come in for oral arguments and it's more for show. Sometimes it can work out a couple of questions the judges may have, but the judges are going to come into that hearing today and they're going to pretty much have an idea of how they're going to rule. We'll be able to write a book after this. I know. This living history's, it's a true story. Yeah, we got to have breaks. We got to have lots of breaks in between, everybody. Yes, and a blooper reel. We gotta get that. Oh my gosh, I have too many blooper reels, people. Yes, Sarah, yes. I had some problems last night. I couldn't come on. I'm not doing much better today. I don't know. Sometimes I get off. I get off of my I get thrown off, and so everything gets kind of knocked to the side, but yes, I had a munchkin that was very sick yesterday, so I think our whole house is still recovering from that. But the munchkin is off. Munchkin was able to go today and be okay. So hopefully everything will be better. Will he appeal? Everything, Timothy, will be appealed. Every single thing, every interlocutory appeal, every motion, every order, anything that can possibly be appealed will be appealed for sure. I have no doubt. I have no doubt whatever. Yes, I know. We got to have some comedy. Yeah, they're okay today. Yeah, just sometimes you get a munchkin that'll go down. It's like, fine. Get out the cookie bucket. Yeah, a lot of people are sick. A lot of people have been getting sick recently. A lot of people. My heart goes out to everyone who's been sick for sure. He's going to appeal the appeal. Exactly, Murray. You're exactly right. He will continue to appeal until the end of time. We will fully experience the appellate process. Yeah, Munchkin down. True story. And I don't know about anybody else, but we actually have like a big bucket. This probably is not good lunch discussion, but you can get the refrigerator cookie dough in. It's this huge bucket. And so whenever anybody gets sick, we have to get the cookie bucket out. Oh my goodness. So yeah, the cookie bucket was out. They're doing better today. But sometimes it happens. Yes. Oh, the Vicks. Yes, exactly. Yes. Well, I think the mistrial may be a good goal, but I don't think it's a realistic goal. I think that I think our judges at this point, even with the language that's in this case and the language that came out of Judge Chutkin's case, I think they're pretty clear. And even actually the Court of Appeals, the appellate division in New York with Judge Engeron, they're like, look, we know what you're doing here and we're not going to do that. So I've got some faith in that. So yeah, the cookie dough is really good, but we gotta have the cookie bucket. Yes, exactly, science labs. Exactly. You gotta, do what you can. Oh my gosh. Yes. When a munchkin goes down, though, it takes down everybody. The whole house, we were all feeling it. Oh my gosh. Yes. The other thing too is that my particular munchkin turns into a koala bear, so there's no removing the munchkin from the person. No baloney. Oh my gosh, 6 munchkins down now. No. I think it's okay to kind of start putting talking a little bit about the Mr. Trump. I think that's okay. I think it's okay to talk as long as you set those boundaries and are like, I don't know. I call it like, I don't know how to swim, everybody, right? So if I go into the pool, I'm always holding on to the side of the pool. So that's how I feel when I have conversations about politics. Like I have one hand on the side of the pool. So I'll just tiptoe around a little bit talking about it. But be very careful about it because I want to be able to get out at any time. That's how I look at arguments with politics. I want to be able to jump out of the pool at any time. Oh my goodness. Oh my gosh. I've not seen yet, Suze, if she's unsealed them. I've seen several filings regarding unsealing them. And I saw several actually that came through yesterday, but I'm not seeing any officially yet. Take lessons. Yes, I did. I took lessons my whole life, everybody. And I just, for some reason, I just can't get it. We can't be great at everything. And unfortunately for me, I'm just not good at swimming. Oh my gosh. Unfortunately, but yes, pretty much everything was denied. Pretty much. Yeah, at this point. Little Joey attached. Oh, I know exactly. You know what I'm saying then. You know what I'm saying, lady. Yeah. Especially when they're sick. They get a lot more clingy. Yes, I'm very careful. If I'm around any bodies of water, I never am by myself for sure. So yeah, I'm also hydrophobic, so that was part of it too. But I tried. I mean, sometimes I feel like if I had to, I could survive just out of sheer anger about being in the situation. But I'm just never alone. So, never alone, lots of life jackets. Oh my gosh. Yes, well, yes. I don't know. All right, so what's coming up on the calendar? So everybody, so for tonight, I will be back on tonight at my normal scheduled time, 7 o'clock. And I'm planning to read, we have a decision out of the New York court regarding, okay, so Rudy Giuliani has been sued, has been found liable, and so now it's going in front of a jury trial to determine damages. So he had filed a motion to say he didn't want a jury trial, he wanted a bench trial. And the judge has issued an order saying, forget about it, you're getting a jury trial. So that order came out, and so I plan to go through that tonight. So I'll be going through it. There's quite a bit to that order. That judge wasn't playing around. So we'll be going through that. Yes, I mean, technically, I think I could swim, Kristen. I mean, I could. I probably could, you know, but the debate's on tonight. Yes. Yeah, that's, oh, yeah. I don't know. Oh my gosh. Yeah, the debates, everybody. I just don't anymore. Oh no, don't worry about it, Navy vet. Don't worry about it. The last few days have been kind of bonkers around here. So I had a very, very dear friend of mine, and she texted me about 7 o'clock this morning, and she said, I woke up and I saw the news and I can't take it anymore. Went to go to prison. I'm like, what? You can't open your morning that way. You have to start off slow, like, good morning. Have you had some coffee? Okay, what's going on? You know, start off a little bit slower. Take a deep breath. It's okay. The whole, one step at a time, everybody. Popcorn does make it a lot more fun. Yes. Oh, absolutely. Absolutely. A little lunch and learn today for everybody, for sure. It's very helpful, I think. But I think, you know, again, the more information that you can get, the more research, the more facts that you can pull together, I think it makes it a little bit easier to just wake up and choose violence. True, true. Yes, why is the speaker digitizing the faces on January 6th? That's a great question, and I don't know. And I don't know why. I mean, I think I know why, but I don't know. That whole situation of pulling that video out is like, what are you talking about? Brief recap. Yes. So this is the U.S. Court of Appeals, the D.C. Circuit. I think I was saying the 11th Circuit, but I'm sorry, that's Florida. This is the D.C. Circuit. And this was on a motion to dismiss the civil lawsuits against Mr. Trump on behalf of the Capitol Police and multiple Congress people who claimed they were harmed because of his actions on the 6th. He said, I can't be sued, presidential immunity, and this court just said you certainly can. So we're going forward on that. We're going forward on the case. What will happen, we don't know, but the Court of Appeals has refused to toss it out. Absolutely. Way more comfortable. Oh, absolutely. Absolutely. I mean, you got to kind of get it sorted so that you can have a better feel for what's going on. It was identifying people to do more charges. Yeah, and you know, that's so interesting though, Rocky, too, because a lot of the charges came about because of the footage that was released. Does everybody remember that? The FBI was putting out little bits and pieces of different clips, and that's how a lot of them were pulled to begin with. So, McCarthy's not returning. I did see that. He's not returning, but he's still in the fight or something like that. I think there was an article written about that. So very interesting. Very interesting. Yeah. Yeah. And I think, you know, I think there's probably a lot more people, but also I think the FBI kind of went for the ones that they felt were the most, at fault. So he's leaving at the end of the month. Yeah. You know, I'm not surprised. It's pretty bad. He had a rough start and a rough ending. So, oh my gosh. Yeah, I think it'll be rough. It was a rough one for him for sure. I've seen the videos. Right. Yeah, and that's the thing too, is really grassroots actually. With people, locals are, if you see somebody on the video that hasn't been identified before, you can call it in. So I mean, there's a lot of questions about that. But then again, even if you call it in and they do an investigation, they still may not charge them. They may not be at that level. I feel like they've really pulled the ones that they felt were the most dangerous of the group and have prosecuted. So he'll be a lobbyist. That makes sense. I wouldn't be surprised. I wouldn't be surprised. I feel no pity. Yeah, I have the same amount as I would for any living being. That's what I have. That's what I have. Can't change all the people. Yes, and exposure. Yeah. I don't know why they're pulling more video out. I felt like there was so much already that if people really wanted it. And the point was, from what I understood, was he wanted to show that everything was peaceful. And, I'm like, well, how's that working out for you? I'm not sure that's working. Oh my gosh. Yeah, and it'll be a while, Kristen. I mean, we took a pretty big hit. We took a big hit for sure. It'll be a while, but it'll, get worked out. It'll be eventually we'll get it worked through once the system takes care of it. But our legal system is so slow, and a lot of people get frustrated with that, and I don't blame you. I don't blame you for getting frustrated, for sure. So, yeah, to prove it was peaceful, exactly, which, you can't, I mean, that's just, you can't do that. There's just too much. There's too much footage that too many people have already seen. That narrative is already gone. That one can't be used. You can use a lot of the other ones, but that particular one is not going to be helpful. Yes, my fancy pen. So, yes, it comes out sometimes. Got to have a little bit of bling sometimes. I don't know. Do people still say bling? I'm so old school and sleep deprived. Oh my gosh. Footage on the site shows. Yeah, exactly, Jim. Exactly. It seems like they're not really, like, what are you doing? Like, your words aren't actually correct, right? Like, why are you giving evidence showing that your words are not correct? What are you doing? I can't. Yes, it matches my nails. Yes. Oh my gosh. Yes. I insurrected again. Whoopsie doos. Yeah, it's a great question. Great question. Oh, thank you. Thank you very much. Yeah, this is one of my favorites. So it's an old school. It's original school. True story. Oh my goodness. True story. So, well, everybody, I will go ahead and let you go. I'm on my way to go tune into the Colorado Supreme Court arguments, and I've got a few things to do around here before my live tonight. So, amazing afternoon. And I will see you all later. Thanks for coming by. It was great hanging out with everybody. So, coordination. Take care. Yeah, I've got to get the tripod sorted. See you all tonight, everyone.